What we wanted to talk about a little bit here was what these, what the seminars doing, the webinars doing, how it's available, and what the different segments of the webinar are for lawyers out there.
Well, we've chosen 5 areas. There are many more than 5 that we could do a program on, but these are areas that people who are doing debt collection and they want to take their practices to the next level or have some questions about where to go once they've filed suit and obtained a judgment, what happens next. There are some issues that are not often discussed but are very important nonetheless. Today we've just completed a segment on evidence in collection actions, how to get your documents admitted before the court. So that's number 1. Number 2, coming up March 29th, fraudulent conveyances, piercing the corporate veil, and charging orders. Now, when I mention charging orders, Illinois doesn't have a process for charging orders, yet it's a malpractice trap for attorneys who are caught unaware because we don't know about it in this state, yet there are several laws that say that the only way to enforce a judgment against a member of an LLC is through a charging order. Okay, now what do? There is nothing written to date. There are no laws on the books. There are just a couple court cases. So this is the type of advanced creditor issues that we will be discussing. We'll also go back to some basics, a little bit of sophistication in citation examinations and the corporate debtor citation exam. What are you looking for? A defunct corporation. How can you pierce without piercing? How can you get at assets that may have been taken by an officer of the corporation? Then in ethics in collections, and I'm not just talking about treating a consumer or opposing counsel ethically, there's some things in the collection practices that we do that don't necessarily jive with our Supreme Court rules. Sometimes cost accounting, advancing court costs, settling cases. In the commercial practice, we do these things daily, but our professional rules, as promulgated by our state Supreme Court, really address more of the personal injury practice and don't consider the bulk of the collection practice, which, by the way, most litigation in the state, other than for municipalities or in criminal cases, are filed in the debt collection arena. And then finally, if you're going to do any consumer debt collection, you must know about the Fair Debt Collection Practices Act. And unfortunately, if you simply read the FDCPA, you'll know next to nothing. Because most of the act, well, the act was not written with attorneys in mind. And then 30 years ago or so, our exemption is removed. And since the act doesn't really make sense as applied to attorneys, courts have been interpreting and reinterpreting and reinterpreting nuance. And so therefore, it's extremely important that we keep up to date before you send a letter requesting money, not on your own account, but for a client's account. You better know whether or not you are violating this important federal act. So those are the issues that we'll address in these upcoming webinars.
Which is fantastic. And really what I wanted to do is just let our audience know a little bit about what these are, how they can be of value, and you hit on at least 5 really succinct points that are of value to each and every lawyer that is out there doing this right now. I imagine this is a changing field these days.
It's constantly changing, but it's not really a new field. Remember, Abraham Lincoln was a collection attorney. Whether you know this or not, you're now going to hear it. 60% of his known court cases were debt collection matters. That was his bread and butter. You hear about some of the famous criminal cases and the railroad cases, but at the end of the day, Abe Lincoln got his start and made his money in this area of practice. Today, it's become much more important because our economy has changed. The way we go about debt collection is different. And so therefore, it's important not only to stay up in this area of practice, but if you don't do collection work properly, you may be committing malpractice. And without naming the case for our audience now, an attorney, a very, very well-respected law firm, obtained $1 million in judgments against someone for some financial shenanigans, and then failed to issue enforcement, citations to discover assets promptly. They got sued for malpractice because the money left the state and moved to Florida with exemptions. So if you don't do this right, you may be committing malpractice.
Advanced Issues in Debt. It's our webinar series. It's available at ICLA. It's available online, and it's also available March through June. $295, I believe, for all segments, and $79 for each separate segment. And Bob Markoff's our moderator. He's also the chairman of the board of IICLE and my great friend. And come on board. Come see our webinar.
Thank you, Patrick. It's a pleasure to be here.
Thank you, Bob.